I'll first introduce the panelists. We have Julie Rickleman, who is the Director of Litigation at the Center for Reproductive Rights. I'm just going to say who they are because their full bios are obviously in the program that you have. This is Khiara Bridges, who is an Associate Professor of Law at Boston University School of Law, as well as an Associate Professor of Anthropology at Boston University. Louise Melling is Deputy Legal Director at the ACLU and the Director of the ACLU Center for Liberty. And Kathleen Clyde is a state representative from the Ohio House of Representatives representing the 75th District. So, as you all know, abortion has been very much in the news in the last several years. I think you can think of it as there being sort of two waves of abortion restrictions that we're seeing. One are more extreme abortion restrictions that directly target women, banning abortion, for example, at early stages of pregnancy. For example, the so-called heartbeat bans that ban abortion as early as 6 weeks of pregnancy, as soon as a heartbeat can be detected, which is often earlier than women may even know they're pregnant. The 20-week bans that I'm sure you've read about that purport to ban abortion when, based on the dubious assertion that fetuses can perceive pain at 20 weeks of pregnancy. We've seen a lot of measures that would define embryos as persons beginning at the moment of fertilization. These measures, I think, are obviously dangerous and troubling, but they are clearly unconstitutional under the Casey undue burden framework. On a parallel track, we have restrictions that target abortion providers themselves and abortion facilities. They don't directly purport to ban abortion, but they have been having that effect, as many of you have read about. They're more insidious because they're not obvious direct regulations of abortion, and they raise really interesting questions for how they should be analyzed under the undue burden standard and what the meaning of the Planned Parenthood versus Casey undue burden standard is. So we're going to spend our time talking about those restrictions, including hospital admitting privileges, which is a prominent example of that type of restriction. Then we're going to spend some time talking about another trend, which is that when we do have the opportunity to impose mandates to provide reproductive health services, then we often have demands by organizations and employers and other entities that don't want to comply with those mandates on the basis of supposed religious objections. And so obviously the Hobby Lobby case that's now pending in the Supreme Court is an example of that. So we will be turning to the issue of religious refusals and reproductive health care in the second part of our panel. And then we will leave 20 minutes for questions and answers from the audience. So I'm going to start with Julie on the first topic. So ever since the Supreme Court decided Planned Parenthood versus Casey in 1992, which changed the standard from the typical strict scrutiny trimester framework that had been established in Roe v. Wade to the undue burden standard, we've seen states experimenting with different types of restrictions that may or may not be considered by courts to be an undue burden. So can you tell us a little bit, I mean, obviously we've seen what we call trap laws, targeted regulation of abortion providers, for many years, but what is different about what we're seeing today?
Sure, thanks, Caitlin. So I think there are three differences. The first one is that these laws, as you mentioned, are definitely more extreme than they had been in the past. The second difference is that the laws are much more clearly targeted at shutting down clinics and choking off access. And the way they're doing that is by heaping onerous regulation on top of onerous regulation in an attempt to force medical practices that provide abortion services to shut down. And as Caitlin mentioned, because these laws generally single out abortion for uniquely burdensome regulations, we call them trap laws, which stands for Targeted Regulation of Abortion Providers. And the third way that this latest wave of restrictions is different is that the states are seeking to justify them based on the claim of protecting women's health. In the past, the anti-choice movement had focused on discussing the state's interest in protecting potential life. But now, for the last few years, it's moved to health and the false claim that abortion is dangerous for women's health. One example of this latest wave of restrictions, as Caitlin mentioned, is the admitting privileges requirement. These are laws that require doctors who perform abortions to have privileges at a local hospital, and that's usually defined to mean no more than 30 miles from where the abortion is performed. Now, this law does not protect women's health, which is why major medical groups like the AMA and ACOG have come out very clearly saying that they oppose admitting privileges requirements. And the fact is that hospitals often make decisions about privileges based on business reasons that have nothing to do with whether or not a particular physician is qualified or good at the type of medical care that he or she provides. And in fact, abortion is already extremely safe. It actually has one of the lowest complication rates of any medical procedure. It's well under 1%. And in the rare event that a complication can't be safely managed in a clinic setting and a patient does need to be transferred to a hospital, the law already requires hospitals to treat that patient, admit her, regardless of whether her particular doctor has privileges at that particular hospital. And you have to remember, of course, that if a woman experiences a complication, she may just need to get to the hospital that's closest to her to get the best medical care for her. And that simply may not be a place where her particular doctor has admitting privileges. Another way that we know that these laws really have nothing to do with women's health is the states that are imposing them, like Mississippi and Texas, don't require doctors who provide any other type of medical procedure to have admitting privileges, only abortion providers. So again, if admitting privileges were so crucial to health, why aren't they being required for other types of procedures? What we've actually seen is that this type of restriction can really endanger women's health, and I want to give you two examples. The main way that it can endanger women's health, of course, is by restricting access to abortion, which already can be very difficult to access for some women in some parts of the country. So for instance, in Mississippi, there's only one abortion clinic left in the state, and it's currently in jeopardy because of an admitting privileges law that was passed in Mississippi several years ago. The hospitals in the local Jackson area, which is where the clinic is located, have been unwilling to provide admitting privileges to the physicians who work at the clinic. And so today, the clinic remains open only because of a federal court order by the trial court there. The case is on appeal to the Fifth Circuit, and if that injunction blocking the law is lifted, Mississippi will become the first state without an abortion clinic, and so women in the state will lose all access to safe and legal abortion in their own state. Another example is Texas. It passed an admitting privileges law that went into effect last year when the Fifth Circuit lifted an injunction granted by a trial court. And after the law went into effect, a number of clinics in the state closed, and in particular, one part of the state, the Rio Grande Valley, was left without any clinics in place. And so women who live in the Rio Grande Valley don't have any access to safe and legal abortion in their part of the state. And what's important to know is that the Rio Grande Valley is a part of Texas where the population is already predominantly poor and where there's already very limited access to health care. So what this law is doing is hurting women's health in the Rio Grande Valley, not helping it.
Thank you. Anybody? I'm happy. So first of all, it's really disturbing to hear about these trends and hear about what they're always doing. So I often say to people, if it makes you feel better to hiss, just to sort of let it out about what's going on in Texas, I just sort of encourage that because it's just hard to swallow. I just want to also supplement Caitlin's paradigm about how the two different ways, right? We'll just call them simply the bans. And then there are the targeting the providers, which I think are just exactly as Julie's saying, which are shut them down and also stigmatize and isolate even further. And then I just have to raise, because I think it should get attention, or we just don't lose sight of it, which are the restrictions that are really going after trying to make women feel really bad because women want to have abortions. So the provisions to mandate ultrasounds, or the provisions now, there's like this new little blip of states trying to extend their waiting periods from 24 hours to 72 hours. And we, in our sort of most dark moments, refer to those as what they think were stupid laws, which are that we can't think and somebody has to tell us
how long it takes us to think. So it is all part of a sort of piece, I think, to make everybody involved in the exercise of our constitutional rights feel really bad. And be stigmatized and ashamed. And I often say, it's as if women who seek abortions and everybody involved in the business of facilitating abortions are being made to feel like the people who still smoke. That it's legal, but we are going to treat you as if you're really bad. And I think that pariah status is something we all have to really pay attention to at the same time. I just want to add, I have many impolite words to describe what I think is happening in the States, but one of the things that I think is interesting in the wave of this sort of devastation, particularly in the South in these cases, is we're seeing a real, I think, and I'm interested in if everybody agrees, a real difference in how the courts are looking at these. Now, you have the Fifth Circuit, and please, we'll just send them away. They can secede. We can't do enough to change the Fifth Circuit, right? And the audacity of the state of Texas that it's not an undue burden unless 50+% of women are prevented from obtaining abortions. Really just horrific. But on the other side, I think confronted with some of these facts, we're seeing judges start to really change how they think about the undue burden standard. So the undue burden standard, shorthand for the conclusion that a state regulation that has the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus is what's unconstitutional. It is a standard that gives everybody tons of room. I often refer to it as like the obscenity standard, right? The judges, they know it when they see it, and for many years they were never ever seeing it, but it gave tremendous discretion to the courts. And for us as litigators, you sort of look at it and you're kind of, so how does the state interest work there? It doesn't even articulate the state interest. The court talks about the state interest, but it's been a challenge. So if you do one thing after leaving this panel, I'd sort of encourage you to read the decision of Myron Thompson coming out of Alabama in the Trapp case, where he, his clerks, whomever, God bless whoever did the thinking behind this, begins to articulate a standard, a way of understanding the undue burden test that is different, that is giving it many more teeth than the courts have really been willing to sort of give it. And in rough terms, what he's really doing is saying, you have to look at the state interest. And you have to ask yourself, is it legit? Like when they say it's about health, is it really about health? You don't just roll over and go, oh, sure, health. And even if it's about health, does it actually sort of further the health? And what is the interest in health? Is it minuscule, or is it going to be a big advantage to women? So you actually analyze, is it real, and how much of an advantage? And then he says, and on the other side, you have to really look deeply at the obstacle. One of the things that's really interesting about what he says there is you actually look at the obstacle in the context of women's real lives. Crazy, right? Not something that the courts regularly do, like, are you rural? Are you living in the Rio Grande? He goes on and elaborates, and he looks at a political context. Will it stigmatize? He even goes to say that cost could be a factor, right? I mean, things that are just sort of unbelievable in terms of what we've been facing in terms of the courts. The Seventh Circuit did a similar, Posner, I think, a similar sort of deep scrutiny of the state, and it's in one of the Trapp cases, the Trapp case coming out of Wisconsin, to say, state says it has this interest, but as Julie points out, nobody else has to do this, so why do we actually kind of believe this interest? They say this was this interest. They didn't put any evidence before the legislature. We have to greet this with skepticism. That kind of skepticism was not what the courts were bringing in any kind of consistent basis. Unless you think it's just about the sort of most blatant. The Ninth Circuit also just issued a decision addressing one of the restrictions on medical abortions, where the court also did a really deep dive balancing. So look, you show up at the office for 20 years doing this, you have to find some ray of hope somewhere, right? So I think it's really interesting to see how the courts, in the face of what's just been a horror show in terms of what restrictions are going through, and the Fifth Circuit I just think is just a shameful, and I think the Supreme Court was shameful also. Other courts really trying to grapple and trying to sort of find a way to work with this awful standard to give it teeth.
Yeah, so Julie had mentioned how one of the things that's different, even though we've seen these kind of Trapp regulations before, including admitting privileges, is the kind of brazenness of them. And so, I think it was the Mississippi governor, right, when he signed it saying, this will end abortion in Mississippi, even as he's saying that this is supposed to protect women's health, right? So kind of blatantly admitting that the actual purpose is to shut down clinics, which may be getting courts to look a little bit more closely at the asserted purpose in litigation. And so I want to ask Khiara to maybe weigh in on what this is doing for the undue burden standard in terms of how the laws are being justified.
Right, yeah. Well, actually, before I get to that, I wanted to just piggyback on Louisa's statement about Myron Thompson's willingness to do this deep dive into why states are passing these laws. I just want to mention there's precedent for that. It's a little case called U.S. v. Windsor, right? Justice Kennedy was willing to look beyond these platitudes about what the Defense of Marriage Act was about. It's about, you know, Scalia spent a lot of time saying, oh, you know, it's just really about uniformity within the federal codes. And Kennedy was like, no, let's look at what this means. Let's look at how this stigmatizes families. Let's look at how this stigmatizes same-sex couples, et cetera, LGBT persons. And so, you know, if the court actually, or if courts actually use that sort of deep dive precedent that's actually there in the context of abortion, we might be seeing different results in these cases. But I do want to just give a little bit of background into the undue burden standard in order to address the question of whether these laws that are now purporting to protect women's health are actually consistent with what the court established in Casey. So, of course, Casey came down in 1992, established the undue burden standard, which replaced the trimester framework, which Caitlin mentioned, that Roe v. Wade established in 1973. Trimester framework completely prohibited any regulations of abortion during the first trimester. During the second trimester, the trimester framework said, yes, you can regulate abortion in states, but only to protect women's health. And during the third trimester, the court said that you can prohibit abortions in order to protect fetal life. States could not try to protect fetal life during the first and second trimesters. And so Casey rejected the trimester framework because Casey said that it didn't give states enough latitude to protect fetal life during the first and second trimesters. Keep in mind now, the court was dissatisfied with the state's inability under the trimester framework to protect fetal life, not to protect women's health. The court thought that states were perfectly capable of protecting women's health via the trimester framework. And so undue burden standard comes along and says, okay, we are going to enable states to demonstrate respect for fetal life and to encourage women to demonstrate respect for fetal life during all stages of pregnancy, not just during the third trimester. And so I'm going to quote from Casey because I think it's important to go back to chapter 1, verse 2 in order to figure out, you know, how we got here in 2014. Casey says, even in the earliest stages of pregnancy, the state may enact rules and regulations designed to encourage her, the woman, to know that there are philosophic and social arguments of great weight that can be brought to bear in favor of continuing the pregnancy to full term, and that there are procedures and institutions to allow adoption of unwanted children, as well as a certain degree of state assistance if the mother chooses to raise the child herself. The Constitution does not forbid a state or city from expressing a preference for normal childbirth. So the undue burden standard, as imagined by the court in Casey, was designed to allow states to express their respect for fetal life and to try to convince women to carry their pregnancies to term. But the way that states could do that was through information, right? The states, Casey said, listen, you can express your respect for fetal life, you can try to convince women, but do it through information. Give them information about adoption. Give them information about the child support responsibilities of fathers. Give them information about welfare benefits to which they may be entitled if they carry the child to term, and then make them sleep on the information. Make them sleep on it 24, 48 hours, right? When, you know, I can talk about how horrible that is for poorer women and women in rural counties. But this was an information-focused kind of intervention. With that bit of background, it should be completely obvious that the new wave of abortion restrictions that we are seeing are not consistent with what the court had in mind in Casey. These new regulations, the outright bans, the hospital admitting privileges requirements, the trap laws generally, they have nothing to do with getting women to change their minds about abortion through giving them information. They're simply about blocking access. They're simply about making it difficult for women to obtain abortions. They're simply about making abortion providers utterly unavailable to them. And so again, Casey did not contemplate protecting women's health, but if we can say that in the spirit of Casey, if the spirit of Casey is about information, then we can say we can only protect women's health, or states can only try to protect women's health through information, right? So give them information about the abortion procedure, about the health risks that it may or may not pose. Give them information about the procedure so that they don't have mental or emotional harm in the future, and we can talk about how problematic that is. This is not what states are doing. States are protecting women's health by actually damaging women's health by making abortion unavailable to them. And just one more little piece. This is chapter 2, verse 3 of Casey, that language that courts are completely ignoring. Casey says an undue burden exists, and therefore a provision of a law is invalid if its purpose or effect is to place a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability. Casey said we have to look into purpose and effects, but certainly purposes of these laws to determine whether they are placing a substantial obstacle in the path of women. So if courts are actually doing what Casey said that they should do, they should be looking into these legislative purposes. And when we have governors and legislators going on record saying, I'm signing this law because I want to shut this clinic down, clearly the purpose is to place a substantial obstacle in a woman's path to an abortion, which is clearly inconsistent under Casey.
We have here someone who is experiencing this right on the ground in Ohio. And actually, I just want to, there was just 2 days ago, I think, or a couple days ago, Think Progress had an article online that was entitled, "Want to understand why abortion clinics are disappearing? Look no further than Ohio." So I want to have Kathleen just talk to us a little bit about what she's been experiencing in her state, and then maybe we can have some follow-up discussion about that.
Great. Thanks, Caitlin. And thanks very much to ACS for having me here, for being there for me as a law student, as a young lawyer, and now as a progressive legislator in Ohio, trying to fight back against a lot of these terrible restrictions on women and women's health. One of the first candidate nights I had when I was running for office, somebody asked me if I was where I stood on abortion, what my views were if I was pro-choice. And I said, of course I'm pro-choice, that's very important to me, but I don't anticipate we'll be dealing with that much in the legislature. We have a lot of work to do on our economy in Ohio, on job creation, on education, and tried to pivot to something that I thought would be more of a focus of my work in the legislature. But unfortunately in Ohio, I've lost count of how many abortion bills have been introduced, how many have passed, and how many debates that we've had on the floor. Usually among the majority of the legislature is men, a lot of older white men making these decisions. I'm glad to be in there and be the young woman's voice on these issues. But we've really seen a lot of attacks on women in the state of Ohio. And I say that too, this isn't just a southern state issue or a deep red state issue. This is happening in the great state of Ohio that helped send Barack Obama to the White House and then reelected him with over 50% of the vote. Yet we are seeing some of the most dangerous restrictions, I would say, in the country being signed into law in what some would view as the progressive state of Ohio. It's not so progressive right now. There's a Republican governor. All of the statewide offices are held by Republicans, and there are Republican supermajorities in both chambers of the legislature. So you're seeing a lot of very extreme legislation coming out of Ohio. We've actually had both types of laws pushed through the Ohio legislature, the bans and the trap laws. So we have examples of both. I'm in my second term in the legislature. In my first term, we had a late term abortion ban pass. We had a ban of abortion coverage by the healthcare exchanges get signed into law. We made the judicial bypass process harder, which is there's a parental consent law in Ohio already on the books. But there's a procedure to get around that if you're under 18 and are in a very difficult situation and maybe can't get that parental consent. But we've now made that much more difficult on young women to bypass that provision. We also had, I think we were the first state to have a heartbeat bill introduced, and that bill actually passed the Ohio House. It did not, thankfully, pass the Ohio Senate, so hasn't been signed into law yet. It's been reintroduced. We also saw some measures in our state budget in my first term. Governor Kasich's budget banned public hospitals from providing abortions, prohibited local government insurance plans from covering abortion services, and provided state funding for abstinence-only sex education in public schools. Fast forward to my second term in office, we've seen a whole host of new attacks on women's health. And these were mainly done in the governor's budget, which is a huge piece of legislation covering all areas of state government. It's about a $60 billion state budget, but slipped in slipped in kind of in the dark of night without opportunity for public hearings and public comments. Just before the governor signed the budget, we had 5 attacks on women that were part of the budget. The first defunded Planned Parenthood in Ohio. The second implemented a forced ultrasound provision on women seeking abortion services. So they are required to undergo an ultrasound in the state of Ohio and also hear a speech from the doctor about the likelihood of the fetuses being born and of their state throughout the pregnancy. We had a transfer agreement, which is similar to the admitting privileges law that was put into place. Basically, an abortion clinic has to have a transfer agreement in place with a public hospital so that if there were some type of emergency, the woman could be transferred to that hospital. Hospitals have to take people in emergencies anyway, so that's not a requirement that should ever be imposed, but it is in Ohio, and public hospitals, clinics cannot enter into those agreements with public hospitals. So in many of our metropolitan areas where there's clinics, the only other hospitals are Catholic hospitals. So what that's done is basically force clinics to close. We've seen clinics close, and it looks like we could be at the point where we have no clinics on the entire western half of the state of Ohio. We also had a gag order put on rape crisis counselors that they are not allowed to talk about abortion as an option to a woman who's just experienced a sexual assault or rape. It's a pretty gruesome provision and part of the governor's state budget. And the final provision was to establish funding for crisis pregnancy centers, which many of you have probably heard of. They often provide very misleading information to women who are pregnant about their different healthcare options. They've been known to tell women that if they get an abortion, they will increase their risk of breast cancer or other false medical information that's being provided. So it's pretty tough right now in the state of Ohio for women, and we're seeing the effect of these laws being to close clinics, to shame women, and are especially hard for low-income women to access services. We've tried to fight back. We held some hearings. Since those provisions didn't have any hearings, we did hearings of our own. Some of the Democratic legislators in Ohio, we've introduced legislation, one to repeal all those measures you heard about, and also some proactive legislation to try to fight back as well. We're trying to educate women and educate people nationally about Ohio. This is going on in Ohio. You need to know about this. This is important. And people need to know about their rights and how they're being attacked. And also, there's litigation going on in Ohio. Thank goodness. Thank you to the ACLU for filing a lawsuit to fight back against these provisions. And it's a tough fight right now, but I appreciate all of you being here to learn about it and assist us in our efforts.
Thank you. One of the, did someone want to give her a hand?
Yes.
Back
We'll
there.
go back.
One of the questions that comes up in these cases is that if you have a state like Ohio that's just bent on shutting down abortion clinics in the state, then you may end up with a state, I mean, Mississippi is another example, that literally has no abortion clinics. And so one of the questions that comes up is whether legislators can justify these regulations by saying, well, they can just go across the state border to X state and get an abortion there. So I'd like to hear a little bit more, maybe from Julie, about what that means in terms of, again, the undue burden standard and the litigating of these cases.
Yes, absolutely. So in the Mississippi case, which the center is litigating right now, the state of Mississippi, realizing that it was very clear that the admitting privileges law would close the last clinic in the state, which would seem to be a quintessential undue burden, put forward the argument that there really wasn't an undue burden because women could just travel across state lines and access clinics in nearby state, and therefore there should be no constitutional problem here. This is a very dangerous argument because obviously if a state can shut down a clinic in Mississippi, why can't Tennessee make the same argument next door, and then Alabama, and then Louisiana, and eventually you get to the point where maybe there's a clinic left in 1 or 2 states because they've now lost the ability to say you can travel somewhere else to access abortion services. So we were fighting that at both the trial court level and then on appeal. At the trial court, the district court judge agreed with us, and he said that that can't possibly be the law, that it's okay to end access to legal abortion because you can access it anywhere, because otherwise you would end up with a patchwork system, was his phrase, across the country where women in some states have the constitutional right, but women in other states do not. When we got up to the Fifth Circuit, we continued to really hash that argument out, and we found a wonderful case from a long time ago called Gaines, where there was a claim brought under the Equal Protection Clause because an African-American man was denied entrance to a state law school, and in defense, the law school said, we'll pay for you to attend law school in a nearby state. But the Supreme Court said no. The state's obligation to provide equal protection of the laws can only operate within its own jurisdiction. And so we said similarly, a state's obligation to give women the due process of law can only be satisfied within its own jurisdiction. And the state of Mississippi can't shut down the last clinic in the state and say that women can go exercise their constitutional rights elsewhere. So we're still waiting for the decision from the Fifth Circuit on that. But I have to say that the Fifth Circuit actually seemed like they were taking that argument pretty seriously, which, as Louise said, is sometimes shocking.
But good in that case.
Yeah.
I just wanted to note that there are many problems with Casey, but I think that courts are taking Casey beyond what was contemplated by the actual Casey court. I think that courts are using the undue burden standard in a way that Casey didn't contemplate at all. But I do want to lodge a criticism at Casey. Another one, because if the court had actually put teeth into what counts as a substantial obstacle in Casey, then we wouldn't see states being able to make these arguments now. So in Casey upheld the constitutionality of a 24-hour waiting period, I think it was, that was in Pennsylvania. And of course, the 24 hours means a whole lot more to a poor woman who has to take time off from work, who has to perhaps stay at a hotel if she's staying far from home, right, in order to go to the one lone abortion clinic that might be available in her area. So that may, in fact, be a substantial obstacle to a poorer woman, to a woman living in rural areas, and it would not be a substantial obstacle to, Justice O'Connor, for example, or people with her class privilege, people with her race privilege, et cetera, people with her privilege of immigration status. But the court, Casey was very, very unwilling to assume the subject position of people without privilege. And Casey was willing to say that, it may be a substantial obstacle, but it's probably not. Had Casey actually assumed the subject position of these poorer women, just like Casey, because they were able to do it, they were able to assume the subject position of a woman in an abusive relationship. The court said, a woman in an abusive relationship, the spousal consent provision, that sounds like a substantial obstacle. So the court was very willing, it was able to step outside of its subject position of privilege, but it was unwilling to do it for poorer women, for people without race privilege, immigration status privilege, etc. If the court had actually done that and put some teeth into what constitutes a substantial obstacle, then we wouldn't see Mississippi able to make the argument like, oh, you can just travel, get on a plane, go to Canada, in order to access your abortion right.
The other thing is just striking when we think about Caitlin's early frame, when we talk about what's happening under Casey and we think about Hobby Lobby, I just have to note, because I have to, that when the court considers whether there's a substantial obstacle, the courts have been, it hasn't been easy to convince them that there's a substantial obstacle, let's just say. But in the religion context, when the court is asked to think about whether there's a substantial burden on religion, there is a very, very different level of deference, just saying.
More on that in a moment.
Caitlin, I do think there's a lot of things about Casey that obviously we don't like, but it seems to me that something like the transfer agreement law in Ohio, some of these admitting privileges laws, it cannot be that when the Supreme Court decided to reaffirm abortion as a protected constitutional right, that it meant it would be okay for states to shut down clinic on the basis of a mere pretext. That can't be what it meant. And actually, if you look at Casey, even though most of the restrictions it considered were restrictions about potential life, the court upheld them only after it concluded that the restrictions actually furthered the state's interest in potential life. And so the way that some lower courts, not the Meyer and Thompsons of the court world, but the way that some other lower courts have been upholding these restrictions, even though there's been no real showing that they will actually help women's health, and there is a real showing that they'll shut down clinics, that does not square with the status of abortion as a protected fundamental right, and it's a misapplication of Casey, I believe.
Yeah, and I think one of the things that's so exciting about the Myron Thompson opinion in the Alabama case is that, as Khiara mentioned, there is this purpose prong in Casey, and it's always been sort of a puzzle as to how that's to be interpreted and how it's to be used, and this feeling that it hasn't been as effective as it seems like it should be. But one of the things that he does in his opinion is reference these ballot access cases that were actually cited in the Casey opinion, and look at how those cases link the effect of a law and the justification that's required. So in the abortion context, he says that the more onerous the obstacle, the more of a justification that's required, which is really exciting because, as we know, and as Julie just said, these are pretexts, and if you just dig very little bit under the surface, you quickly see that that's not the purpose of the laws, that they're not consistent with that, but you need a court that's willing to do that, and certainly the burden that they're imposing is substantial enough that it should trigger that kind of scrutiny.
But what he does is something even better in the sense that he's not putting the state interest in the purpose side, right? In the sense that purpose is such a complicated thing, right, to prove purpose. If we think about, so it's lovely that the governor of Mississippi was so foolhardy as to say exactly what he was doing, right? I mean, not that that's going to win the case in the Fifth Circuit.
Not in the Fifth Circuit.
But it should, right? But purpose, we know purpose it can be challenging, and we all sort of know it, but it's a harder thing. What he does is, Casey does talk about, as Khiara was pointing out, like the state interest, the two different state interests in health and fetus, and he draws that out to sort of say it can't be that that state interest doesn't matter. So his real test is, as you were saying, the balance, and he has a little section about the purpose, which says, yes, they talk about purpose, but purpose is harder, but it's better for us. It's truer. It's how the Constitution works. It's back to Julie's point. If this is a constitutional right, and the state's going to restrict it, surely the state has to do something, right? Casey doesn't stand for the proposition, this is rational review, and we just whatever. And he's actually trying to find a way to work with what the court said and give it meaning, in part, very interestingly, relying on these voting cases.
Right. So we're going to be able to come back to this topic in the Q&A, but I want to make sure that we have enough time to turn to religious refusals and reproductive rights. And so I just want to ask Louise to maybe frame this in a broader way, and then we can talk more specifically about the Hobby Lobby decision. But more broadly, what is the impact of Sibelius versus Hobby Lobby stores and Conestoga Wood Specialties versus Sibelius? Obviously, have been argued in the Supreme Court on March 25th, and we're awaiting decision any day now, probably next week. And so, what are sort of the broader implications of those decisions, and or what are the broader implications that this decision will have for reproductive health access, and also obviously other kinds of civil liberties?
So first of all, I just have to start out by saying, how crazy is it that we're having a conversation about access to contraception in the 21st century, right? We shouldn't have had to wait until this late to get this access, and the idea that we're now having a debate about sort of its morality and whether or not you can make employers provide this, I just find, we'll say, breathtaking. Want to note that Hobby Lobby, right, getting a ton of attention as things do when they go to the Supreme Court, and as they should when they go to the Supreme Court, is just one iteration of this conversation that's happening today about when institutions in particular can refuse to comply with a law and in these instances in particular a law that's advancing rights. So there's Hobby Lobby and the other 80 some odd cases, right, all floating around to create what I actually view as like a social protest statement in some significant way. Simultaneously, we have in the states litigation over shop owners, businesses, inns, cake shops, photography, florists, yada, 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 who refuse to provide any of their services to lesbian and gay couples, in particular around commitment ceremonies, who are arguing that it's their First Amendment right. In legislative debates, there's no debate happening today to advance rights, in particular of LGBT people. That does not involve a robust debate about how broad the exemption should be in the state legislation or at the federal level, for example, see ENDA. There's litigation with Christian schools that have fired teachers because they're pregnant and unmarried or because they use assisted reproduction, and in the face of lawsuits against them saying it's against our religion. So and at the state level, like the federal RFRA, and I'll get to that in a second, is presenting complications here. But at the state level, the states are trying to pass RFRAs that make the federal RFRA look like it's really protective of civil rights, in the sense that they'll say any burden, no substantial, and direct and indirect burden. So there's a ton of activity going on, and Hobby Lobby, in some respects, I think won't actually speak directly to that activity, but will have a great implication, if that makes any sense. And so Hobby Lobby, federal statute, there's a constitutional claim, but nobody thinks that's going to be the deal, because the federal standard says if the law is general neutrally applicable, then it passes constitutional muster. So the question is whether Hobby Lobby is burdened under the meaning of the Federal Religious Freedom Restoration Act, which applies to federal laws. It is not the test for any state laws or lower level kinds of laws. And the question is, is there a burden on a substantial burden on a person? And if so, is it justified by a compelling state interest and narrowly tailored? So the $6 million questions, right? Is the arts and crafts shop a person? Can the arts and crafts shop be substantially burdened, and is it substantially burdened? Is there one theory is that it's not burdened because it doesn't actually have to comply, it could just opt out and pay a penalty. Another theory is it's not substantial, this burden, and then is there a compelling state interest served by a narrow means? So I think no matter how the decision comes out, Hobby Lobby will speak to this question. But I think the ongoing debates sort of about LGBT rights, for example, are not in any way squarely decided by this. But I have to bet courts are going to view LGBT rights differently, in the sense they'll find a different compelling state interest. I mean, that's the dynamic that we're seeing all over the country, right, in terms of reproductive rights versus state rights. I think there'll be big pushes by the different sides for more expansive RFRAs versus those who will want to amend the RFRAs, so that RFRAs provide less maneuvering of this nature. When we think about its implications for reproductive rights, first of all, if we lose, it's just a body blow, in the sense of that we can't even convince somebody that our right to contraception is this important, right? And so that's bad. when I think about the rest of reproductive rights, let's just keep in mind, let's just put this in context. The entire country is wallpapered with laws giving everybody who wants out, in particular from abortion, an out. As early as 1973, Congress passed a law that says that the fact that you get federal dollars can never be used to require you as an institution to provide abortion services. We now have a federal law that says the federal government can take money away from you, state agency, if you discriminate against an institution because it doesn't want to refer for, pay for, or provide abortion. States are full of laws like this. So in some sense, in my most cynical moment, I think, well, I mean, we don't have that much else to lose. But I think the good side, right, my little optimistic hat, is I think people are really upset. People are really agitated about this Hobby Lobby debate. People really don't think that your boss should be able to say to you that you can't do this. And what we're actually seeing in some of the states is an awakening to the fact that this occurs. If you then say to them, oh, and by the way, at that hospital, they don't even have to provide you care. If what you need is abortion, your doctor doesn't even have to give you a referral. People really don't like that. So I'm hoping that however this comes out, perhaps it will provide, we can sort of rally either people's feeling of strength if we win or feeling of frustration if we lose, to try to reinvigorate the conversation about reproductive rights in this arena. And I have to say, I beg you to drive hard that this question is out there. It really stinks that people don't want to touch abortion, don't want to have I've been at a million of these religious refusals conferences, and people were like, oh, that's different. Everybody's, concerned about the exemptions in the context of LGBT rights, but much less willing to engage in this conversation and really figure out how to push. The idea that this is about discrimination isn't embedded in people's brains, even though last time I checked, access to contraception and abortion were incredibly important for discrimination, but people are not making that connection. And we have to take this as our opportunity to really drive home and make those connections and try to change the landscape.
Somebody want to weigh in?
Yeah. I think that just exactly where you ended, Louise, to me, this case is very much about the ongoing question of whether ordinary constitutional principles apply when reproductive rights are at issue. Because even if it's decided under RFRA, of course, incorporated pre-Smith constitutional jurisprudence, and one of the old Supreme Court cases named Lee was a case where the U.S. Supreme Court said that an employer could not get an exemption for religious grounds from a general law if the effect of the exemption would be to impose his religious views on his employees. So that's a Supreme Court decision decided years ago. Depending on how Hobby Lobby comes out, there might be a different rule when reproductive rights are at issue. And so to me, that's a big question, and it's a question that also comes up in our ultrasound cases. You wouldn't necessarily connect the two, but it's really the same question. Do ordinary First Amendment principles apply when what's going on has something to do with reproductive rights? And it's really crucial and important because, as Louise said, it keeps being put into a different bucket.
I think it's important to underscore what Louise said, that this is about discrimination, because we have to imagine what the world looks like when women don't have access to abortion, but to contraception, right? It forces women into a particular role of child bearers. It forces women outside of the public sphere of public activity. These are civil rights we're talking about, right? Like, civil rights are, if we have a definition for them, it's those rights that you need in order to participate in the public sphere, right? And so this is about what it's going to mean to be a woman, right? This is
Exactly.
this is, and so thank you, Louise. And I think that's the point that we have to draw, underscore, that it's not about religious freedom yet. No, this is about what it means gender is going to mean in the upcoming years.
I just can't resist saying more. Which is, I think one of the issues is that contraception and abortion are increasingly treated as like services, right? And they get talked about as if like women actually weren't engaged in them, as if it wasn't about us in some really profound fashion. Mm-hmm. And I think that's one way it gets. I still haven't recovered from Geduldig. And so I'm blaming Geduldig for part of this. I think it's probably not, in fact, exactly responsible in this particular way, but that women's reproduction and discrimination against us based on that sort of doesn't have to do with women. It's just bananas. But I think there's exactly what you're saying. This is about our equality story, and that has somehow just, like, I don't know, evaporated from the ozone in a really, at least in the public ozone, in a profound way.
Before we turn to our Q&A session, I just want to ask if, Louise, could you give a really brief mention of the nonprofit cases and what's going on with those? Because I know there have been some interesting decisions in the circuit courts, especially in the Sixth Circuit recently. So, I mean, one of the questions that the Supreme Court is going to have to address is whether the for-profit status of these companies is significant in some way. But nonprofit or religious organizations are treated differently under the contraceptive rule. And so there have been some decisions on that score.
So once upon a time, before this litigation started, the Council for the U.S. Conference of Catholic Bishops, I believe, said, like, oh, if I were Taco Bell, I'd be objecting to the contraception rule. And I remember we heard this in our office, and we're like, oh, great quote, that'll really help us. That's bananas, right? And then all the for-profit cases started coming along. And so then along comes the nonprofit rule, right? So the rule for nonprofits is that nonprofits that have an objection based on religious grounds and are religiously affiliated organizations certify, basically, I object, and then their insurance company is supposed to pick it up. So it was then, clearly the Obama administration conceived of this sort of as a win-win. We'll let them sort of try to have a feeling that their hands are clean, but we'll still make sure women have access. So the first challenges file on that with the nonprofit saying that signing the piece of paper constitutes a substantial burden, and okay, we laughed. We're not laughing so hard anymore. In the district courts, the courts are ruling more consistently in favor of the nonprofit entities. There have been 2 decisions now in the courts of appeals where the courts have actually ruled in favor of the government. Hobby Lobby, may or may not address the question, right? It has to be in the justice's mind. It has to be in the justice's mind in particular in a very interesting way if the court goes all the way to the question of substantial interest. Is there a compelling state interest, not substantial, compelling state interest, and is it narrowly tailored? Like, they can't easily just say, oh, it's not narrowly tailored because you could have given that accommodation, the way maybe I sort of imagined they might before these cases were so active. So they have to have that in mind. But it is a $6 million question in some sense about what the court is going to say about substantial burden and what constitutes a substantial burden. Again, as Julie was pointing out, it constitutes a substantial burden on that entity, right? I mean, and I think this, again, back to challenges we have. One of the challenges is to give people a real sense of who's on the other side, right? Julie's right, and the SG at the very end of his argument said if the court rules in favor of Hobby Lobby, the court will be doing what it never has done before. It will be doing to say that the employer can sort of take away a benefit and impose this cost on somebody else. And that third-party harm, both as a visual and as a legal matter, is incredibly important in terms of how people understand this, both in terms of the nonprofit and the for-profit cases. But as you can tell, I should just give up on predictions since everything that I sort of thought was crazy now is just moving up through the courts with different results than I anticipated, with more complicated results. We don't know the real results yet.
That's true. So before we go to Q&A, I just wanted, was there anything else that you would like to add?
And just listening to some of this is making me think about the conservative effort, by those in power, certainly in Ohio. It's this death by 1,000 cuts. Strategy that is being pursued both in kind of 3 areas in Ohio and I think across the country on workers' rights, voter rights, and women's rights. And it's to take our progressive movement and make us fight so many battles on so many fronts and take away the power of our progressive organizations. Planned Parenthood is a very politically active organization that supports progressive women and progressive policies in state legislatures. And these direct attacks on them are political and about trying to consolidate more power on one side. And, we really need to realize that and sort of realize the overall agenda here. And it's pretty disturbing stuff. And I think all of those fights are really linked as we think about this landscape.
That's a great point. So we have some time left, a little over 15 minutes for questions. And I think there will be microphones going around. Am I right? Yes, there's a microphone going around. I just ask people to keep their questions relatively brief so we can get as many in as possible. And just raise your hand if you want it, if you want the mic.
So, thank you. I don't know, is this on? Okay, so, I don't think it's on, but, oh, but there we go. So, I wanted to make 2 points, because I actually believe I've been at this for 30 years, and I think that
Kitty
most of
argued Casey for people.
most of the precursors of what's going on today were there from the very beginning. What isn't here now were things we saw in the years after Roe that I think we need to bring back. And I just want to add that in many ways the religion piece and the restrictions on abortion in the early days were very much combined because there was a religious voice in support of abortion rights. And I think we're missing that now politically, and that's really important in order to not have the religious argument always be opting out. So that's one piece I'd like to raise. The second is, I think what the right did, and what we're seeing in Ohio and we're seeing across the country, is they understood that taking over the states was the most critical thing to do, and that they did that with the census, they did that with redistricting. The reason Ohio is all Republican is because of redistricting, not because they're right on the issues or even that they have support on the issues. And so what I would like to just urge us to remember is the courts reflect the politics of the nation. I love the fact that some of the judges are beginning to be more emphatic, and I actually think that's because women started to wake up. You know, the Virginia situation with the ultrasound, with women really fighting back, and the Wendy Davis activism, the women are kind of going back to being much more aggressive about their opposition to this is really great, and I want to encourage that. But I also think we need strategically to remember that redistricting, the 2020 elections are the most critical factor, and that we should be starting now to plot out how we can at least take over one, section of government in every state so that we have some leverage in that redistricting fight. Because otherwise, the fears we had from before Casey, that these laws would continue to progress and take over state by state, are coming true. Let me just add one more thing, which is Khiara's argument about Casey being limited to information provisions only, I really don't think is right, because that was the issue that was before the court. And so the reason they said that is because they were upholding a 24-hour waiting period with informed consent provisions. I don't really think they believe that. But in addition, I do think they gave us some language that was much more protective than we ever thought we would get. And that language, while the courts in the intervening years have not been supportive of, I think Louise's point is that some of the courts now are beginning to put some teeth to that, and that's a great development. So, but to me, it's not ever going to happen across the board until the politics of this issue, state by state, change.
Can I just, on the politics front, just want to say I couldn't agree more. Ohio, for us, for it to be a Republican wave year in 2010 has just been devastating in Ohio and across the country because it was a redistricting year in so many states. Ohio has a very broken system for how we do redistricting. The Democrats in the Ohio House actually won more votes than the Republican candidates, but they locked up a supermajority and have just been ramming through very extreme legislation. It's unchecked at this, for another 10 years until we're able to redraw the line. So you're exactly right.
And I just wanted to say that in terms of fighting back on the political front, there was a bill introduced in Congress last November, the Women's Health Protection Act. And it would be another very important tool for fighting these restrictions because it would essentially render these restrictions invalid. So restrictions that target abortion for uniquely burdensome treatment but aren't applied to similar medical procedures would be invalid. Restrictions that don't actually advance women's health while pretending that they advance women's health but actually close down clinics would be invalid. So that would also be a very important tool for us, and it is something that we're doing to fight back.
Hi. I noticed with, and I observed with the incredible pace of the gay rights movement and the way the same-sex marriage has been legalized across the country, that it's been a lot of discovery and reflection of regular people realizing, oh, they know these people, they're happily married and they happen to be gay and they love each other and that's fine. And I was wondering if I get your opinions on, and I don't know the exact numbers, but I know whenever I see them, the amount of women who've had abortions is much higher than what a lot of people expect. It's much more prevalent than what people would expect. And I mean, obviously there's a lot of shame as to why they don't come out, but whether or not that would perhaps change people's opinions if more people came out and spoke out and said, yes, I had an abortion, it didn't change me, and in fact, aside from the fact it perhaps saved me, it helped get me out of poverty, it gave me the opportunity, and whether or not more of that could, make this issue not being, we wouldn't have such a closed perspective on it.
Yeah, I'd love to agree with you. Like, I absolutely agree with you. So one hat that I wear is my lawyer hat, but the other one is an anthropologist. I study culture. And I think that it's important that we recognize that we are trying to win this particular battle around reproductive rights via law, via courts, via legislatures. But there's another battle that we should be fighting simultaneously, and it's the culture war. Scalia likes to conceptualize LGBT rights as a culture war. Well, let's conceptualize, reproductive rights as a culture war as well. And I think part of the battles that we can fight about the culture war is the coming out, right? Is the I had an abortion. Or even the more controversial one, I take birth control pills, right? like I think that if we come out and normalize and perhaps it will destigmatize some of the conversations that we're having, and make it seem as ridiculous as it is that we're debating whether women should have access to the birth control pill in 2014.
There also, there's research, there are studies about the best ways to tell stories, and this was true for LGBT as well as for abortion, that if I stood up today and told a story or whatever, that people are pretty quick to judge if they don't know you. So the very first, for LGBT certainly, the initial wave was tell somebody who knows you. So if somebody already likes you or already gives you the benefit of the doubt in some way, then it's going to disrupt, and they're uncomfortable with LGBT folks. It's going to disrupt their sense. Whereas if they don't know you, then they can sort of hold on a little bit. So some of the early research certainly is with many things, right? The first place to be persuasive is with people who are close to you. You start in your inner circle of communication, and then you start building out. There was just a small study done with a book called Choices. It's a book that has collections of essays of women telling their experiences, and they're not just abortion experiences, but the book was given to, I think it's 14 or 30 reading groups around the country, and they took a survey of people in the reading group before, and then they took a survey of people after, and they took a survey of people 4 months later. In the groups, apparently, I think my memory is correct, something like 80% of the women who had abortions revealed their abortions during the book group discussion of the book, and they hadn't told their book group partners about their abortions before. And the study showed a change in attitudes after, particularly among the people who had negative attitudes, because these were people who already came together. So I think that's just one factor to sort of think about as we go forward. But yeah, as I say, like a movement that's silent can't win, right? If we're in shame, we can't win.
Right. I think one thing that's really important about that question and that comparison is that, if a lesbian or gay couple wants to get married, that's something that they're very excited about and they intend to do for the rest of their life, and it's, it's something to celebrate. The thing about abortion is, obviously it's impossible to encapsulate, a single abortion experience for everyone, but But certainly, you know, women tend to have abortions when their pregnancy is untenable for some reason, and it's not something that sort of defines their life, right? The abortion allows them to move on with the life that they have, to finish their education, to care for children they already have, whatever the case may be. And so I think it's unrealistic to expect, although we should encourage and create opportunity for women who want to tell their stories to do that. I think it's really important for people who've not had abortions, but who know someone that they love or respect or care for who has had an abortion, to talk about that. Maybe not to identify the person, but in some cases people have done that and talked about how their mother had an abortion or whatnot. And I think that that the more people can just generally speak about and normalize abortion, whether or not they've had one themselves, I think that's important specifically in the abortion context.
Hi. Over here. The question I had is kind of on the flip side of reproductive rights, which is kind of the increasing criminalization of pregnant women in terms of like if they've been using drugs, they're immediately jailed, or even the kind of seizing of prenatal care and birth choices that women have once they get into hospitals. And it kind of seems to be this like damned if you do, damned if you don't situation. And I just kind of wanted to know what advocacy on that end of the situation looks like, and if there's a considerable amount of overlap in the people who are dealing with both the choice to end your pregnancy and the choice to continue your pregnancy in a safe manner.
Yeah, excellent question. I'm not sure about whether the advocates are the same, but I certainly know that there are a lot of law professors who are concerned about both questions. I also wanted to mention the damned if you do, damned if you don't catch-22 is present right there between the laws that prohibit Medicaid from funding abortions, as well as the laws that, so it's encouraging women to have these children, but then there are so many laws that punish women for actually having children, poor women, right, from having children, like family caps and all the punitive approaches that TANF is taking towards poor mothers. So it's like, you know, if we did the sort of deep dive that we were talking about that Myron Thompson did in Alabama, and like look what is the state's deal here? Like, does it like babies and want them to be born, or does it not like babies and don't want to, like, so I think it's really about a question of autonomy, right? Like, we're constricting poor women's autonomy, and we can, you know, write books about why that is. Why don't we trust poor women to make decisions for themselves?
Ian Milheiser with Think Progress. So we've got these terrible laws in Ohio that'll eventually wind up in the Sixth Circuit, and there's a vacancy on that Sixth Circuit that President Obama cannot fill unless he gets Mitch McConnell and Rand Paul's permission. Myron Thompson's opinions will appeal to the 11th Circuit, where there are 2 vacancies that he cannot fill unless he gets Saxby Chambliss and Johnny Isaacson's permission. And for those of you who don't know the price that he has to pay for that permission, I'll just drop the name Michael Boggs. So I've heard at times from my friends in the repro community that it is more important to play defense on judicial nominations, so there was some reluctance to liberalize the rules in the Senate amongst some members of the community. And I'm curious, you know, what's your take on this? You know, do we need to fundamentally change the confirmations process so that when we have this Casey framework that essentially delegates abortion rights to the United States Circuit Courts, it is actually possible for Democratic presidents to confirm judges in the circuits that are most likely to have bad abortion laws?
How about that?
I mean, I'll say a little bit on that. I think that the vacancies issue is a huge one, and I'm glad you bring that up in this particular context and in the Sixth Circuit context as well. I'll also say that one of the problems we have is we don't have unlimited funds to be litigating all of these cases. It's this issue in particular, and I was discussing this before we started, is hard to find pro bono legal representation for. This is an issue that people, and I encourage all of you to help change this, but that people shy away from, don't want to be the law firm that's the pro bono litigant in an abortion case. So there's a lot of issues with litigation and whether this is the way that we should be fighting these battles. As a legislator, I would say these are political battles, and we need to have more progressives elected into office that care about these issues that will fight back there before it gets to that stage. But I'm happy to probably. Someone else may want to talk about the vacancy issue more.
In my personal capacity, it has been deeply troubling, right? That even when you have Democrats, that what you get is at best moderates, people who don't hate abortion, right? In a sense, we haven't seen the kind of forward thinking necessarily put on the bench in recent years on some of the progressive issues the same way some of the Republican presidents have been able to put into the bench in other places. I mean, your point goes back, though, to the core question here, which is how the hell do we stop abortion from being the third rail in this profound way, right? I mean, and how do we start to begin to sort of shift these cultures in ways, part of it's electoral, part of it's judicial, part of it's the culture change, part of it's the bench. I realize, right? Problem easier identified than solved, but I've got nothing to say about the process.
So unfortunately, we are out of time. Thank you so much for your excellent questions. I just have an announcement that I was asked to make, which is that lunch, including the luncheon plenary, Reflections on Windsor, begins immediately following this panel in the presidential ballroom and is followed by the plenary panel Beyond a Broken Beltway.
So you can go to the
Thank you so
upbeat
much.
lunch now.